Good evening, Dean, and good evening, classmates. This evening, our group will discuss on torts, its definition, concept, elements until its scope. The group members are Reynald Montano, Casan Ali Limbona Jr., Cristina Guibone, Angelica Segue, Grace Bation, Guibone Bahil, Christine Jade Utuhan. Our group assistant leader is Quelton Amba, and yours truly, the group leader of Group 1 is Carlito Aceron Jr. At first, we will have to define what is torts. Torts is an unlawful violation of private right not created by contract, and which gives rise to an action for damages. It is an act or omission producing an injury to another without any previous existing lawful relation, of which the said act or omission may be said to be a natural outgrowth or incident. In other words, it is a private or civil wrong or injury other than breach of contract, for which the court will provide a remedy in the form of an action for damages. What are the examples of torts? Example of torts includes trespass, assault, battery, negligence, product liability, and intentional infliction of emotional distress, nuisance, defamation, and invasion of privacy. So if someone trespass your property, assault you in person, defame your honor, and invade your privacy, there will be consequences of that injurious action, and it could be filed in court, so the result will be damages. Abuse of right, its concept. Article 19 of the Civil Code on Human Relation contains what is referred to as the principle of abuse of rights. Sets certain standards which may be observed not only in the exercise of one's rights, but also in the performance of one's duties. These standards are the following: to act with justice, to give everyone his due, and to observe honesty and good faith. The law therefore recognizes the primordial limitation on all rights, that in their exercise, the norms of human conduct set forth in Article 19 must be observed. In Article 19 of the Civil Code, it states that every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. So there is a limitation on all rights. When it exceeds to that certain limitation, it may result to the abuse of one's rights. How to test of abuse of right? As we learned from our previous slide, that Article 19, also known as the principle of abuse of right, prescribes that a person should not use his right unjustly or contrary to honesty and good faith. Otherwise, he opened himself to liability. There is an abuse of right when it exercised solely to prejudice or injure another. The exercise of a right must be in accordance with the purpose for which it was established, and must not be excessive or unduly harsh. There must be no intention to harm another when exercising a certain rights. Otherwise, liability for damages to the injured party will attach. Before I end my topic, I have to show you a sample case presentation of what I have discussed earlier, which is the abuse of right. Thank you. University of the East, the petitioner versus Romeo E. Hadir, respondent. GR number 132344, February 17, 2000. Facts of the case. Respondent Romeo Hadir sued petitioner University of the East for damages for the moral shock, mental anguish, serious anxiety, besmirched reputation, wounded feelings, and sleepless nights he suffered when he was not able to take the 1988 bar examination arising from the latter's negligence. Hadir alleges that he got an incomplete grade in Practice Court 1. He took the removals exam for said subject, but he was belatedly informed that it was incomplete. The graduation ceremony invitation included his name as one of the candidates, but the invitation had a footnote that the list is tentative and still subject to the completion of requirements. Hadir attended the ceremony. He marched with his parents and was given a symbolic diploma, took pictures, tendered a blowout attended by neighbors, friends, and relatives, took a leave of absence without pay from work, and enrolled at a pre-bar review class. In its answer, petitioner denied liability, arguing mainly that it never led Hadir to believe that he completed the requirements for an LLB degree when his name was included in the tentative list of graduating students. The issue of the case: may a university be held liable for damages for misleading a student into believing that the latter had satisfied all the requirements for graduation? The ruling of the court: yes, it may be held liable. Article 19 and 20 of the Civil Code states that every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. And every person who, contrary to law, willfully or negligently causes damage to another, shall indemnify the latter for the same. Educational institutions are duly bound to inform the students of their academic status and not wait for the latter to inquire from the former. Petitioner ought to have known that time was of the essence in the performance of its obligation to inform respondent of his grade. It cannot find ignorance that respondent will not prepare himself for the bar exam, since that it is precisely the immediate concern after graduation of an LLB graduate. Hence, petitioner is liable for its failure to promptly inform respondent of the result of an examination, and in misleading the latter into believing that he had satisfied all requirements for the course. Good evening once again, and thank you for listening.
Good evening, everyone. I am Quelton Amba, and I am assigned to discuss the elements of rights and the principle of damnum abscia injuria. Article 19 of the Civil Code, which is known to contain what is also commonly referred as the principle of abuse of rights, provides for the elements in order to determine whether the act or omission committed violates the right of another. These elements are as follows. Number one, there is a legal right or duty. Number two, such duty is exercised in bad faith. And number three, it is for the sole intent of prejudicing or injuring another. It must be emphasized that the absence of good faith is essential to the abuse of rights. Under the abuse of rights principle, good faith refers to the state of mind which is manifested by the acts of the individual concerned. It consists of the intention to abstain from taking unconscionable and unscrupulous advantage of another. As you can see in the picture, an example maybe of this topic is the case of racism, where racist commits injustices against the minorities. And in order to fully understand this topic, let us tackle the case of California Clothing Incorporated versus Quiñones. GR number 175822, October 23, 2013. The facts of the case: respondent bought a pair of black jeans worth 2,098 pesos from Guess USA boutique. While she was on her way to Mercury Drugstore, a Guess employee approached her and said that she failed to pay for the black jeans. Nevertheless, she presented an official receipt and suggested that they should talk about the matter in Cebu Pacific office located within the mall. While they were in the office, the Guess employees allegedly humiliated her in front of the clients of Cebu Pacific, repeatedly demanded payment, and even searched for the respondent's wallet to check how much money she had. Now for the issue of the case, whether the petitioners acted in bad faith. The Supreme Court ruled, yes, the petitioners acted in bad faith and that the award for moral damages and attorney's fees to the respondent was proper. The principle of abuse of rights under Article 19 of the Civil Code is present in the case. The respondent complained when the petitioners embarrassed her and insisted that she did not pay for the black jeans despite the issuance of an official receipt in her favor. The principle of abuse of right is complete in the present case. First, the petitioner continued to insist that there was no payment made when the respondent already presented the black jeans with the original receipt. Second, they accused the respondent that not only did she fail to pay for the black jeans, but she intentionally stole it and quickly left the shop. And third, the letter sent to the respondent's employer was not only intended to ask for his assistance in collection of the payment, but also to ruin the respondent's reputation. And now let's proceed to discuss the principle of damnum abscia injuria, which is also known as damage without injury. In the case of Spouses Custodio versus Court of Appeals, the Supreme Court distinguished damages from the injury in order to fully understand this concept. Injury is the legal invasion of a legal right, while damage is the loss, hurt, or harm which resulted from the injury. Damages are also a recompense or compensation awarded for the damage suffered. Hence, there can also be damage without injury in cases in which the loss or harm was not the result of a violation of a legal duty. As an example of which is like what happens to Nokia and iPhone. Nokia, after iPhone introduces smartphones. Though Nokia company suffers damage from the competition, however, there is no injury as the loss suffered by Nokia is not a result of a violation of a legal duty. As it happens also in a lot of cases, a person sustains actual damage, for example, harm or loss to his person or property without sustaining any legal injury. This is an act or omission which the law does not deem an injury, and the damage is therefore regarded as a damnum abscia injuria. This principle contemplates a situation wherein the person exercises a certain right for a good purpose, however, still a damage was caused. And again, in order to fully understand this principle, let us tackle the case of Banaria versus Banaria, GR number 217806, July 28, 2020. The facts of the case: respondents allege that as early as February 2003, or a year before, they planned for the 90th birthday celebration of their father, Pascasio. Adelaida, stepmother of Banaria siblings, promised to bring Pascasio in his scheduled birthday celebration, although it coincides with the death anniversary of her mother. The plan was to bring Pascasio to the venue in the early morning of February 22, 2004, before proceeding to her hometown in Tarlac. However, much to the dismay of the Banaria siblings, as well as to their guests, Pascasio was nowhere to be found in his 90th birthday celebration. Respondents continuously called Adelaida, but they were not able to contact her. And almost 200 guests were at the venue waiting for Pascasio. Enough for the issue of the case, whether this is a case of damnum absquia injuria. The Supreme Court ruled no. Damnum absquia injuria, or damage without injury, may not be appreciated in petitioner's action, as said principle contemplates a situation wherein, in the exercise of a right, though the purpose was good and the exercise normal, but still a damage is caused. As applied to the petitioner's actions, her failure to inform respondents of their intended absence from the party of their whereabouts, in the least to the extent that the respondent found it necessary to file a missing persons report with the local police, exhibits the utter lack of consideration for the respondents, or otherwise a deficit in good faith relations with the latter. So that's all for my report, and I hope you learned something to the topic we have discussed. Thank you and good evening.
Good evening, Dean, classmates. Tonight, I will be reporting on unjust enrichment. The fundamental doctrine of unjust enrichment is the transfer of value without just cause or consideration. The elements of this doctrine are enrichment on the part of the defendant, impoverishment on the part of the plaintiff, and lack of cause. The main objective is to prevent one to enrich himself at the expense of another. It is commonly accepted that this doctrine simply means that a person shall not be allowed to profit or enrich himself inequitably at another's expense. Article 22 of the Civil Code of the Philippines enshrined the concept of unjust enrichment. It is which provides that every person who, through an act of performance by another or any other means, acquires or comes into possession of something at the expense of the latter without just or legal ground, shall return the same to him. There is unjust enrichment when a person unjustly retains a benefit to the loss of another, or when a person retains money or property of another against the fundamental principles of justice, equity, and good conscience. And now for the illustrative case, Halandoni versus Incomenda, GR number 205578, March 1, 2017. For the facts of the case, Incomenda narrated that she met petitioner Georgia Osmeña Halandoni in Cebu on October 24, 1985, when the former was purchasing a condominium unit and the latter was the real estate broker. Thereafter, Incomenda and Halandoni became close friends. On March 2, 1997, Halandoni called Incomenda to ask if she could borrow money for the search and rescue of her children in Manila who were allegedly taken by their father, Luis Halandoni. Incomenda went to Halandoni's house and handed 100,000 pesos in a sealed envelope to the latter's security guard. While in Manila, Halandoni again borrowed money for the following errands. On April 1, 1997, Halandoni borrowed 1 million peso from Incomenda and promised that she would pay the same when the money in the bank matured. Thereafter, Incomenda went to Manila to attend the hearing of Halandoni's habeas corpus case before the Court of Appeals, where 100,000 pesos more was requested. On May 26, 1997, now crying Halandoni asked if Incomenda could lend her additional 900,000 pesos. Incomenda still acceded, albeit already feeling annoyed. All in all, Incomenda spent around 3,245,836 pesos and 2 centavos and $6,638 and 20 centavos for Halandoni. The issue in this case is whether Incomenda is entitled to be reimbursed for the amounts she defrayed for Halandoni's, considering that she claimed that they were given without her knowledge. The court held that clearly Halandoni greatly benefited from the purportedly unauthorized payments. Thus, even if she asseverates that Incomenda's payment of her household bills was without her knowledge or against her will, she cannot deny the fact that the same still inured to her benefit, and Incomenda must therefore be consequently reimbursed for it. The principle of unjust enrichment find application in this case. Unjust enrichment exists when a person unfairly retains a benefit to the loss of another, or when a person retains money or property of another against the fundamental principle of justice, equity, and good conscience. There is unjust enrichment under Article 22 of the Civil Code when, number 1, a person is unjustly benefited, and number 2, such benefit is derived at the expense of or with damages to another. The principle of unjust enrichment essentially contemplates payment when there is no duty to pay, and the person who receives the payment has no right to receive it. The Court of Appeals is then correct when it ruled that allowing Halandoni to keep the amounts received from Incomenda will certainly cause an unjust enrichment on Halandoni's part and to Incomenda's damage and prejudice. The doctrine of unjust enrichment finds its application in one of the civil law questions of the last 2019 bar examinations. The question is this: Miss U, a usufructuary of a piece of land owned by Mr. L, during the existence of the usufruct, introduced various useful improvements on the land. Upon the termination of the usufruct, Mr. L requested Miss U to remove the improvements made thereon. Miss U refused, demanding instead that Mr. L reimbursed her of the value of the same. Now the question: is Miss U's demand proper? Explain. The answer: no. Under the Civil Code, there is no right granted to the usufructuary to demand reimbursement for any improvements made, nor is there any obligation on the landowner or the landowner to reimburse for any improvements made by the usufructuary. Notwithstanding applying the principle of unjust enrichment, Mr. L may be compelled to pay for the improvements made by Miss U. Miss U have to remove them at her expense. In the case at bar, Miss U do not have the right to demand reimbursement. Neither does Mr. L have the obligation to pay for the improvements unless he chooses to appropriate it. Thus, Misuse demand is not proper.
Good evening, everyone. Today I'm going to be talking about the relevant provisions pertaining to the doctrine for the principle of unjust enrichment. The first article is Article 22 of the Civil Code, which provides that every person who, through an act or performance by another, or any other means, acquires or comes into possession of something at the expense of the latter, without just or legal ground, shall return the same to him. This encapsulates the principle against unjust enrichment, which embodies the Roman law principle of nemo cum ulterius detriment locupletari potest, which means no one shall unjustly enrich himself at the expense of another, as cited with the court in Pacific Merchandising Corporation versus Consolacion Insurance and Surety Corporation Incorporated. 73 SCA 564. The second article that we must take notice of is Article 23 of the Civil Code, which provides that even when an act or event causing damage to another's property was not due to the fault or negligence of the defendant, the latter shall be liable for indemnity if through the act or event he was benefited. The next two provisions we must take notice of are Article 2142 and Article 2143, which provide that certain lawful, voluntary, and unilateral acts give rise to the juridical relation of quasi-contracts, to the end that no one shall be unjustly enriched or benefited at the expense of another. Meanwhile, Article 2143 provides that the provisions for quasi-contracts in this chapter do not exclude other quasi-contracts which may come. To further elucidate the concept of unjust enrichment, we provided to you the case of Philinvest Land vs. Ngilay, GR number 174715, October 11, 2021. Respondents were grantees of agricultural land through a homestead patent, which is covered by 17 original certificates of title issued within the years 1986 to 1991 by the Registry of Deeds of General Santos City. Petitioners initiated negotiations for the purchase of the properties owned by the respondents, and eventually a deed of conditional sale was executed in favor of petitioner, upon which the respondents were asked to deliver the original owner's duplicate copy of the certificates of the properties belonging to the Ngilays. They also received from the petitioners a down payment for the properties. However, after some time, respondents found out that the sale was null and void due to being executed during the period wherein the sale of the land was prohibited by law, and that it did not have the approval of the Secretary of the Department of Environment and Natural Resources. Hence the issue of the case. Whether or not the down payment given by Philinvest Land should be returned by the respondent Ngilays. The ruling. The court ruled on the positive. On the grounds of the principle of unjust enrichment, the money given by petitioner should be returned. The rule is settled that the declaration of nullity of a contract which is void ab initio operates to restore things to the state and condition in which they were found before the execution thereof. Petitioner is correct in its argument that allowing respondents to keep the amount received from petitioner is tantamount to judicial acquiescence to unjust enrichment. As discussed earlier, unjust enrichment exists when a person unjustly retains a benefit to the loss of another, or when a person retains money or property of another against the fundamental principles of justice, equity, and good conscience. Furthermore, there is unjust enrichment under Article 22 of the Civil Code when, first, a person is unjustly benefited, and second, such benefit is derived at the expense of or with damages to another. Thus, the sale which created the obligation of petitioner to pay the agreed amount having been declared void, respondents have the duty to return the down payment as they no longer have the right to keep it. The principle of unjust enrichment essentially contemplates payment when there is no duty to pay and the person who receives has no right to receive. Thank you and have a great day.
Liability without fault. Relevant provisions. Article 22 states that every person who through an act or performance by another or any other means acquire or comes into possession of something at the expense of the latter without just or legal ground shall return the same to him. Also, Article 23 states that when an act or event causing damage to another's property was not due to the fault or negligence of the defendant, the latter shall be liable for indemnity if through the act or event he was benefited. Duty to indemnify because of benefit received. Unless there is a duty to indemnify, unjust enrichment will occur. This provision imposes liability without fault as long as the injurious act or event benefited the defendant. This article is based on equity. An involuntary act, because of its character, cannot generally create an obligation, but when by such act its author has been enriched, it is only just that he should indemnify for the damages caused to the extent of his enrichment. The indemnity does not include unrealized profits of the injured party, because the defendant's enrichment is limited to his liability. The plaintiff has the burden of proving the extent of the benefit or enrichment of the defendant. Example: without A's knowledge, a flood drives his cattle to the cultivated highland of B. A's cattle are saved, but B's crops were destroyed. True, A was not at fault, but he was benefited. It is but right and equitable that he should indemnify B. Another relevant provision is Article 2176. Whoever, by act or omission, causes damage to another, there being fault or negligence, is obliged to pay for the damage done. In some cases, tort law imposes liability on defendants who are neither negligent nor guilty of intentional wrongdoing. Known as strict liability or liability without fault, this branch of torts seeks to regulate those activities that are useful and necessary but that create abnormally dangerous risk to the society. Ubania v. Court of Appeals and Sandoval, 135 SCRA 557, March 29, 1985. Facts of the case. On November 21, 1964, Angelito Sandoval, owner of Sandoval's and Sons Rice Mill, was approached by Chanlin, who offered to purchase from him 170 cavans of rice at price of 37.25 pesos per cavan. The driver attempted to collect the payment from Chanlin and petitioner Angelito Sandoval, but the latter refused, stating that he had already made payment to Chanlin. Further demands having met with refusal, Sandoval as plaintiff filed suit for replevin against petitioner before the Municipal Court of San Fernando, La Union, which ordered petitioner-defendant to pay to Sandoval one-half of the cost of the rice, or 2,805 pesos. On appeal by the petitioner to the Court of First Instance, judgment was rendered dismissing the complaint. On appeal to the Respondent Appellate Court, Sandoval obtained a reversal in his favor. Hence, the present petition seeks for the review of the decision of the CA ordering Ubania in action for replevin to return to Sandoval, private respondent herein, 170 cavans of rice, or to pay its value in the amount of 37.25 pesos per cavan, with legal interest from filing of the complaint until fully paid. Issue: whether or not the petitioner-defendant has unjustly enriched himself at the expense of another by holding on the property no longer belonging to him. Ruling: the judgment under review is hereby affirmed. Cost against petitioner. No person should be benefited without a valid basis or justification, shall enrich himself at the expense of another, and hold on to a property no longer belonging to him. The petitioner defendant in his own testimony said that he was repaid the sum of 5,600 by channeling and claimed that he delivered the rice back to them. However, the driver denied that the rice has been returned. The driver's version is more credible since Sandoval's lawyer had manifested in open court that they would have withdrawn the complaint if the return of rice has been effected. In law and equity, therefore, Sandoval is entitled to recover the rice or the value thereof, since he was not paid the price therefor.
Acts contrary to law. Under Article 20 of the Civil Code, every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the latter for the same. There are three requisites. Number 1, the act must be willful or negligent. Number 2, it must be contrary to law. And number 3, damages must be suffered by the injured party. The damage caused to another in the exercise of his legal right or duty may have been committed wittingly or unwittingly, but this will not vindicate the offender from his obligation to indemnify the party for the damage done. It should be noted that his act or omission causes damage to another either because of his fault or negligence. An example case is Arco Pulp versus Dantilim, GR number 206806, June 25, 2014. The facts of the case. Dantilim is engaged in the paper mill business under the name Quality Paper and Plastic Products Enterprises. Lim delivered scrap papers worth 7,220,968.31 to Arco Pulp and Paper Company Incorporated through its Chief Executive Officer and President, Candida A. Santos. The parties allegedly agreed that Arco Pulp and Paper would either pay Dantilim the value of the raw materials or deliver to him their finished products of equivalent value. Upon the delivery of the raw materials, Lim alleged that Arco Pulp and Paper issued and post-dated check as a partial payment, assuring that the check will not bounce. When Lim deposited the check, it was dishonored for being drawn against a closed account. Despite repeated demands by Lim, Arco Pulp and Paper did not pay. Lim filed a complaint for collection of money with prayer for attachment with the RTC. The trial court rendered a judgment in favor of Arco Pulp and Paper and dismissed the complaint, holding that when Arco Pulp and Paper and Eric C. entered into the Memorandum of Agreement, novation took place, which extinguished Arco Pulp and Paper's obligation to Lim. But the CA reversed the decision. The issue of the case: whether petitioners are liable for damages. The ruling of the court: yes, petitioners are liable for damages. Under Article 2220 of the Civil Code, moral damages may be awarded in case of breach of contract, where the breach is due to fraud or bad faith. Moral damages are not recoverable simply because a contract has been breached. They are recoverable only if the party from whom it is claimed acted fraudulently or in bad faith or in wanton disregard of his contractual obligations. The breach must be wanton, reckless, malicious, or in bad faith, and oppressive or abusive. Here, the injury suffered by respondent is the loss of 7,220,968.31 from his business. This has remained unpaid since 2007. This injury undoubtedly was caused by petitioner Arco Pulp and Paper's act of refusing to pay its obligations. When the obligation became due and demandable, petitioner Arco Pulp and Paper not only issued an unfunded check, but also entered into a contract with a third person in an effort to evade the liability. Persons who have the right to enter into the contractual relations must exercise the right with honesty and good faith. And failure to do so results in an abuse of that right, which may become the basis of an action for damages. Article 19, however, cannot be its sole basis. Article 19 is the general rule which governs the conduct of human relations. By itself, it is not the basis of an actionable tort. Article 19 describes the degree of care required so that an actionable tort may arise when it is alleged together with Article 20 or Article 21. Thank you.
Good day, everyone. Good day, Dan. My report is about acts contrary to morals. In Article 21, any person who willfully causes loss or injury to another in a manner that, in contrary to morals, good customs, or public policy, shall compensate the latter for damage. 1. Acts contrary to morals. Every good law draws its breath of life from morals, from those principles which are written with words of fire in the conscience of men. There is no belief of more baneful consequences upon the social order than that a person may with impunity cause damage to his fellow men, so long as he does not break the law of the state, though he may be defying the most secret postulate of morality. In Article 21, distinguished from Article 20. Article 21, the act is done willfully, while in Article 20, the act is done either willfully or negligently. Example, a student willfully humiliates a professor, causing her a half nervous breakdown. This would be contrary of good customs and morals, and the professor can sue for damages. Example given by the Code Commission: A seduced the 19-year-old daughter of X. X, a promise of marriage either has not been made or cannot be proved. The girls become pregnant. Under the present criminal laws, there is no crime as the girl is above 18 years old. Neither can any civil action for breach of promises be filed under Article 21. She and her parents would have the right and action for damages against A. But note, the example given by the Code Commission is correct, provided that the man had in some way defrauded or deceived the girl. But if the two of them had engaged in illicit relationship out of mutual carnal lust, then it is believed that there can be no recovery of damages, since both parties are at fault. The same rule applies when it was the girl who deliberately tempted the man. Can there be an action for breach of promises to marry? For the recovery of actual damages, yes. Thus, if a person gives another 500 pesos because the latter promised to marry the former and the promise is not fulfilled, the money is given can be recovered. Example, the case of Cecilio P. et al. Versus Alfonso P. The facts of the case. A married man who was the adopted son of a relative of a girl's father and had the same family name as a girl became very close to the girl and her family. In fact, the members of the family considered him as one of them. In 1952, the man thus frequented the house of the girl, Lolita, on the pretext of desiring to teach her how to pray the rosary. The two eventually fell in love and meet each other in clandestine triads over the objection of the family. One day, in 1957, the man wrote Lolita a note asking her to have a date with him. Lolita went to him. Her parents, brothers, and sisters now sue the defendant under Article 21. Held. The Supreme Court, applying at Article 21, ruled that indeed he, a married man, has seduced Lolita through an ingenious and tricky scheme to the extent of making her fall in love with him. Verily, he has committed an injury of Lolita's family in a manner contrary to morals and good customs and public policy. He was therefore ordered to pay 5,000 pesos as damages and 2,000 as attorney's fees, in addition to the expenses of the litigation. A married man, and B, an unmarried woman, entered into a written agreement to marry each other when A becomes a widow. After becoming a widower, A married another woman. Can B sue A for breach of promise? Answer, no. Insofar as moral damages are concerned, moreover, to engage in such a promise during the lifetime of another spouse would be contrary to good morals and good customs, and the agreement, even on that ground alone, must be considered void. In an addition based on breach of promise to marry, what right has the aggrieved party in cases? A, when there has been carnal knowledge. Answer, the aggrieved party may ask the other to recognize the child, should there be one, and give support to said child. Second, the aggrieved party may sue for moral damages if there be a criminal or moral seduction, but not if the intercourse was due to mutual lust. Third, the aggrieved party may sue the actual damages should there be any such as the expenses of the wedding preparation. B, when there has been no carnal knowledge, there may be an action for actual and moral damages under certain conditions, as when there has been deliberate desire to inflict loss or injury, or when there has been an evident or abuse of right. Thus, a man who deliberately fails for appears at the altar during the scheduled wedding simply because it was the intention, embarrass of humiliate the girl, no doubt inflict irreparable injury to her honor and reputation, wound her feelings, and lead the way for her possible social ostracism. The girl in such a case can recover not only actual but also moral exemplary damages. Thank you and have a good day.
Good evening, everyone. My topic for this evening is all about the classification of torts. Let us start with the manner of its commission. So as we all know, if there be fault or negligence, one is obliged to pay for the damages done for such fault or negligence. If there is no contractual relations, it is called is a quasi-delicт. So under which are the elements of quasi-delict, act or omission, and the presence of fault or negligence for such act or omission. There is injury, and there is a connection between the negligent act and the injury, and there is no existing contractual relation. For intentional torts, it compasses abuse of rights. So acts that are contrary to law and morals. The mere breach of promise to marry is not an actionable wrong. But to formally set a wedding and go through all the preparations and publicity, only to walk out of it when the matrimony is about to be solemnized is quite different. And the defendant must be held answerable in damages in accordance with Article 21. There are 4 requisites for the intentional infliction of emotional distress on the second part. Number 1 is the conduct of the defendant was intentional and reckless regard of the plaintiff, and the conduct was extreme and outrageous. There is connection between the defendant's conduct and such mental distress of the plaintiff, and such mental distress was extreme and severe. For strict liability, number 1, liability for the product and services. Number 2, animal liability. So possessor or owner of animal who had made damages to another shall be held responsible even though such animal escaped or lost. But such responsibility ceases if it comes under force majeure. So even though you are not the owner of the house, but you are in possession of the dog who had have beaten a child and which caused the latter's death in a few days, such possessor of the animal is deemed liable. For numbers 3 to 8, these are examples of strict liability. Number 3, registered owner for the vehicle. So LGUs given charge or in charge for the roads, streets, bridges, public buildings, and their public works. Private owners of buildings and structures. Head of the family with regard to his family. Public and private nuisance. And number 8, physicians violating the doctrine of informed consent. So what is informed consent? So it is a liability may arise in case where the physician fails to obtain the consent of the patient before performing any medical procedure. So because of that, of such consent, the patient may intelligently exercise his judgment by reasonably balancing the probable risk against probable benefits of such treatment. So, substitute informed consent would refer to when a patient is already dead and was not able to make his informed consent known, there are a list of persons who may do it in his behalf. So that is called substitute informed consent. Now, what are the 4 elements that you may seem to say that there is malpractice on the doctrine of informed consent? So number 1, the physician should have the duty to disclose such material risk to the patient, but was not able to disclose it. And number 3, there is a direct and proximate result of the failure to disclose to the patient's consent. So hindi siya na ginawa. If he was able to do it, if I was made known of such risk, and after that, the plaintiff was injured because of that proposed treatment. Let us proceed to its scope. So the first one is the general scope. So it falls under the generic definition of a tort or quasi-delict and is not subject to certain specific provisions. So torts fall into 3 general categories. Number 1, intentional torts, negligent torts, and strict liability torts. Now let's go to the specific scope. So these are specific provisions applicable such under strict liability. So specific already. So it includes such as trespass, assault, battery, intentional infliction of emotional distress. One classic example of such emotional distress, wherein Islamic Dawah Council of the Philippines filed in the complaint for damages in their own behalf and as a class suit in behalf of the Muslims members nationwide against a certain publication incorporation arising from an article published by the latter, which says that baboy at kahit anong uri ng hayop sa Mindanao ay hindi kinakain ng mga Muslim. Para sa kanila, ang mga ito ay isang sagradong bagay. Hindi nila ito kailangan kainin kahit na sila pa ay magugutom at mawala ng ulam. Ginagawa nila itong Diyos at sinasamba. The complaint alleged that the libelous statement was insulting and damaging and disparaging to the Muslims and Islam in violation of law, public policy, good morals, and human relations. Now, the issue of the case, is there an existence of the elements of libel and the right of respondents to institute the class suit, then the liability of the petitioners for formal damages, exemplary damages, attorney's fees, and the cost of the suit. The court ruled in the negative. Declarations made about a large class of people cannot be interpreted to advert to an identified or identifiable individual. Absent of such circumstances, specifically pointing or alluding to a particular member of a class, no member of such class has a right of action without at all impairing the equally demanding right of free speech and expression, as well as of the press, under our Bill of Rights. That ends my report. Everyone, thank you and mayong gabi sa atong tanan.
Hello everyone, my name is Christine J. Duguhan and I will present some sample bar questions for us to be able to appreciate more of the topic. So, number 1, is abusive rights actionable? Explain. The answer is yes. Abusive rights is actionable. This is clear from the provision of Article 19 of the new Civil Code, which declares that every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. And from the provision of Article 20, which declares that every person who, contrary to law, willfully or negligently cause damage to another, shall indemnify the latter for the same. Number 2. There was a sale of a motorcycle with mortgage as security for the payment of the balance of the purchase price. When the vendee failed to pay, the seller went to the buyer's establishment with the police and ordered the seizure of the motorcycle, which he even mouthed a slanderous statement. Sued for damages, he contended that there is no liability for the exercise of the right as seller mortgagee to recover the mortgage vehicle preliminary to the enforcement of his right to foreclose on the mortgage in case of default. Is the contention correct? Why? The answer is no. If a mortgagee is unable to obtain possession of a mortgage property for its sale and foreclosure, he must bring a civil action either to recover such possession as a preliminary step to the sale or to obtain judicial foreclosure. The seller failed to bring the proper civil action necessary to acquire legal possession of the motorcycle. Instead, he descended to the buyer's establishment with his policemen and ordered the seizure of the motorcycle without a search warrant or court order. Worse, in the course of the illegal seizure of the motorcycle, the seller even mouthed a slanderous statement. No doubt, the seller disregarded the lawful procedure for the enforcement of its rights, to the prejudice of the vendee. Its acts violated the law as well as public morals and transgressed the proper norms of human relations. Number 3. Differentiate Article 20 from Article 21 of the Civil Code. So, Article 20 speaks of the general sanction from all other provisions of law, which do not especially provide for their sanction. Article 21, on the other hand, speaks of act which is legal but is contrary to morals, good custom, public order, or public policy, and is done with intent to injure. So we proceed to the next question, number 4. Rian borrowed a sum of money from a professional lender payable on a quarterly basis. However, because of her workload and other important matters to attend to, she was not able to keep track of her obligation to him and made an overpayment for 2 quarters. When she asked for the return of the money, he did not address her properly. Can Rian still recover the excess payment of her indebtedness to her lender, even if it was discovered a bit late already? And the answer is yes. Rian can still recover the excess payments she made. What transpired in her situation is the principle of unjust enrichment that is provided under Article 22 of the new Civil Code. There is unjust enrichment when 1. A person is unjustly benefited, and 2. Such benefit is derived at the expense of or with damages to another. Hence, she may demand for the return of the excess payments made because he is already unjustly enriching himself at Rian's expense. If despite demand, the lender refuses to return the same, she may institute an action in court for damages to recover the same under the principle of unjust enrichment. Next, number 5. Michelle accused her neighbor, Idina, of stealing her necklace on the eve of her wedding day. She claimed that Idina was the only person who immediately entered the restroom after she used it. She further alleged that she placed her necklace on the lavatory. However, Idina did not see anything when she was inside the restroom. Idina was really embarrassed because every visitor was looking at her when her relatives were searching her bag and packets, while she kept on shouting that nobody would have taken the necklace except Idina. The search of her personal belongings yielded to nothing. Is there any case which Idina can file against Michelle? And of course, the answer is yes. Michelle clearly abused Idina's right when she accused her of taking her necklace without any proof. Worse, Idina was subjected to a physical search in front of her visitors while she kept on claiming that she had taken the missing item, openly branded Idina as the thief. Her action is not clearly justified under the circumstances. She had willfully caused injury to Idina in a manner which is contrary to morals and good customs. She did not act with justice and good faith, for apparently she had no other purpose in mind but to prejudice Idina. Certainly, she transgressed the provisions of Article 19 in relation to Article 21, for which she would be held accountable. This is one example of abuse of rights which can be a source of civil action for damages against